The CBI registered a very serious FIR on 19 September in which the CBI says that there was a conspiracy and preparation to bribe judges of the Supreme Court in a matter relating to a medical college which had been pending and had been heard on different dates in the Supreme Court. After this FIR, the CBI also raided many of these people, arrested even a retired judge of the Odisha High Court. This investigation could easily be used by an agency under the control of the government to pressurize and thereby compromise the independence of the judges, because it involves an investigation into sitting judges, and this matter happened to be dealt with throughout by the Chief Justice, by the present Chief Justice. So it was a very sensitive issue where we felt that it would be totally inappropriate to leave this investigation in the hands of a government controlled agency, and therefore we felt that it should be taken out of the hands of the government and given to a totally independent SIT, which should be headed by a retired Chief Justice of the Supreme Court. That's why we filed this petition. We are saying that this investigation should be transferred, and this is a serious matter, and this matter should be heard preferably by at least a bench of 5 judges, of the senior most 5 judges. Now, strictly speaking, because the Chief Justice himself had passed all those orders relating to that medical college, and the allegation in the FIR is that the conspiracy and preparations were to bribe the Supreme Court and the judges dealing with this case, which means the Chief Justice, then strictly speaking, the Chief Justice firstly ought not to deal with this matter on the judicial side, nor even on the administrative side. He should not be even deciding which judge should hear this case or not. That should be decided strictly by the second judge in seniority. Yes, certainly some very strange things happened. Day before yesterday, that is on the 8th, we had mentioned the petition of the Campaign for Judicial Accountability and Reforms before Court number 2, because the Chief Justice was in a constitution bench. And in any case, this was not a matter which he should have been dealing with at any rate. The Court 2 ordered it to be listed on Friday before his court. But during lunchtime, we were informed that there were some instructions of the Chief Justice not to list it before Court number 2, but to list it before some other bench. Thereafter, Kamini Jaiswal filed a second petition, which was filed yesterday, and it was mentioned for urgent hearing yesterday before Court number 2. He ordered it to be heard before him at 12:45. However, some very curious development took place just before that. It appears while this hearing of this case was in progress in Court number 2 at 12:45, after that some registrar came to the court and handed over a administrative order to the court saying that there are instructions of the Chief Justice that such matters which are mentioned before Court 2 when the Chief Justice is in a constitution bench should either be listed before the Chief Justice at 3 p.m. or instructions must be obtained from the Chief Justice as to where it is to be listed. And this administrative order is purported to be dated 6th of November, but obviously Court number 2 was not aware of this order, and it's curious as to why it was handed over in a hurry while this hearing of this case was in progress. It's also curious that the Chief Justice was in a constitution bench, sitting in a constitution bench yesterday, and the constitution bench suddenly rose at noon, at 12, and did not sit thereafter until 2 p.m. And suddenly at 12:45 this order was hurriedly brought to court number 2. In any case, you see, it is, in my view, improper on the part of the Chief Justice to try and deal with this matter either on the judicial or on the administrative side, because he is himself involved in this matter, because the FIR is purportedly directed against him as well, because the conspiracy is said to be to bribe him. So therefore, whether or not he is involved in this, it's not proper for him to hear this matter either on the judicial side or even pass orders in this matter for fixing benches on the administrative side. Yes, there are some similarities, because again, you see, in the Calico Pull matter, the allegations were also against the then Chief Justice, and strictly speaking, he ought not to have exercised either administrative or judicial powers in it. He didn't exercise judicial powers, but he exercised his administrative power to send it before court number 12, which one of the very junior benches, which was not quite proper, and at that time also Mr. Dushyant Dave had raised this issue before the bench hearing the matter. But the bench said that, look, since the Chief Justice has sent it to me, we have to hear this matter, at which point Mr. Dushyant Dave withdrew that petition. Yes, you see, unfortunately this government's track record in misuse of the CBI is very, very bad. Of course, even the previous governments used to do that with political personalities. But of late, we are observing a trend where there is certainly very serious apprehension that this use of the CBI to pressurize and thereby influence even judges has started going on. There appear to have been cases involving previous judges also. I wouldn't like to go into the details of that, where it appears that these kind of agencies were used to pressurize judges and to influence them.